This section deals with the controversy over the Bush and Gore recount in 2000. The issues surrounding the election results of 2000 may well be relevant for the upcoming election in November of 2020. In the 2000 election, the winning votes were left to be determined by the results of the state of Florida and its 25 electoral votes. Gore had actually called Bush to concede the loss of the election, but hours later called to recant his concession, as the vote in Florida was much closer than he had initially believed. Less than 600 votes separated the two candidates, and as time progressed, that margin appeared to be narrowing. Florida law mandated a machine recount where the difference was less than 0.05%. In this case, the margin was even thinner, roughly 0.01%. By November 10th, 3 days after the November 7th vote, the difference was recorded in the machine recount as 327 votes out of a total vote of some 6 million. There then arose various issues dealing with what were called hanging chads, pregnant chads, overvotes, undervotes, and the butterfly ballots, the latter being used only in Palm Beach County. Hanging chad is a voting card which was not completely punched. A pregnant chad is one in which the vote card is dimpled but not released from the card. Overvote is a ballot which had recorded multiple votes for the same office. An undervote recorded no vote for the relevant office. The butterfly ballot allegedly caused confusion with Gore voters and it inadvertently caused votes to go to Pat Buchanan. These are the issues that prompted the litigation, which in essence centered on the question of whether manual recounts should be allowed, which were intended to resolve these issues. Initially on December the 8th, the Florida Supreme Court ordered a manual recount in districts in which there was a significant number of undervotes for the presidency. Bush immediately sued, and the U.S. Supreme Court ordered the next day that the manual recount should stop, pending completed oral arguments from both sides. The Supreme Court then made two further rulings on December 12th. The first, in a 7-2 decision, ordered that the recount decision violated the Equal Protection Clause of the 14th Amendment of the Constitution. The second decision dealt with a remedy that was then to be applied, given the first finding. This was a 5-4 decision, with each justice deciding in favor of the party which had nominated the relevant justice to the court. The majority concluded that the initial Florida court decision had created new election law, which was beyond the court's jurisdiction, was rightly a matter for the legislature and not the court, and no recount could be held in time to satisfy a federal deadline for the election of Electoral College. Bush, as is then known, succeeded. The dissenting judges concluded that the recount process indeed suffered from flaws, but should be allowed to continue as the constitutional protection of each vote should be overridden by a timeline. There are other possible outcomes to this 2000 voting chaos. By the Constitution, Congress could have determined which of Florida's electors it could recognize, a formidable task, to say the least. Congress also could have determined that neither candidate had achieved a majority of Electoral College, which also seems to be quite a leap. In the latter case, the 12th Amendment allows the House of Representatives to declare the winner. This actually did happen in the 1824 election of John Quincy Adams. A similar crisis arose in 1876. The Democrat candidate Samuel Tilden won the majority of the popular vote, but he was unable to secure the majority of Electoral College due to disputes in various states. Congress then appointed a special 15-member commission to deal with this issue. A compromise was reached by which Rutherford B. Hayes would become the president, but Union shoulders would be withdrawn from southern states, effectively ending the post-Civil War Reconstruction period. This election remains possibly the most disputed presidential contest to date. The issue in Bush versus Gore was whether the law should follow the Florida state law, which determined how votes were to be counted. More precisely in this case, how they should be recounted. The court decided that the manual recount was offside the Florida law by 7-2, but more importantly, the remedy decision was a 5-4 split. The dissent is very important as it proposed to allow the manual recount even when contrary to the state law. In 2020, with the issue of mail-in voting so prominent, the role of the state law will very likely rise again, as some states insist that only votes received by the election date may be counted, and others use the date on which the envelope was postmarked. Generally speaking, most states require that all ballots be received by the time at which the polls close on Election Day. This being said, Pennsylvania and Nevada are in court over attempts to change that deadline to permit ballots received after Election Day to be counted. The highest court in Pennsylvania, in a ruling on Thursday, September 17, stated that as long as the ballots are postmarked by 8 p.m. on Election Day, they would be counted if they are received by Friday of the election week. A federal district court in Georgia ordered the state to count absentee ballots received by November 6, although the state plans to appeal. 22 states do allow the counting of mailed votes, which arrive after Election Day, as long as they are postmarked on or in advance of Election Day. The particular time deadline varies state by state. These states count for 313 of the nation's 538 electoral college votes, being 58%. This is one reason why the winner of the president race may not be declared on Election Day. Generally speaking, these 22 states allow for one extra week to receive and count the mail ballots. Washington State, however, allows for a delay until November 23rd to count mail ballots. To add more context to this, some states do allow for the early counting of mail-in ballots, although the results cannot be disclosed until Election Day. Arizona and North Carolina allow for the counting of these votes as early as 14 days prior to the official date of the election. Ohio also allows ballots to be counted, but similarly not announced prior to the election date. Other states allow mail-in ballots to be processed, that is, verified and scanned prior to the election day, and then prepared for the counting on Election Day. Pennsylvania and Michigan are attempting to pass legislation in the Republican-controlled legislatures to reverse the law which currently prohibits the processing of mail ballots until Election Day. The Pennsylvania proposed new law has passed and is waiting for Senate approval. However, the amended law would eliminate the use of drop boxes for the collection of the ballots. The governor, a Democrat, has stated that he will veto the law for this reason. In Wisconsin, there is a federal court case pending to request more time for the processing of mail-in ballots. A Michigan Court of Claims Judge Cynthia Stevens, on Friday, September 18th, ordered that all ballots postmarked before election date will be counted, as long as they are received within 14 days of the election. Normally, state law requires that all ballots be received by 8 p.m. on the day of the election. Only 9 states and the District of Columbia and certain counties in Montana, Nebraska, and North Dakota will send a mail-in ballot to every voter. Of these 9 states, Oregon, Washington, Utah, and Colorado have followed this practice for years. Hawaii was using this process before the pandemic. Only one of the states now implementing this process is a swing state, Nevada. 35 states allow any voter to request a ballot by mail. In the 6 remaining states, voters need an acceptable reason to vote by mail. These are Indiana, Louisiana, Mississippi, South Carolina, Texas, and Tennessee. A recent attempt in Wisconsin to add the Green Party to the ballot caused further delays to the mail ballots. A Supreme Court judge in that state ordered election officials to temporarily stop mailing of ballots until the issue could be decided. Should this issue have been determined in favor of the Green Party, new ballots would have needed to be printed and mailed out. A more recent court decision denied the Green Party this right, and the ballots are now on the way out. In yet another lawsuit to a similar effect, Kanye West also seeks the same spot on the ballot after a prior decision by the state's election commission was that he had missed the filing deadline. In 2016, roughly 25% of the ballots cast were made by mail, this being some 33 million votes. There's no date set by the Constitution for the counting of the votes from the Electoral College. The customary date is December 14th. Florida State Senator Marco Rubio has proposed a bill to extend this date to January 2nd. Add to this mix the apparent alleged attempts by the management of the post office to disrupt the mailing process, there's a good chance the counting of the ballots will be nothing short of chaotic. A federal judge, U.S. District Judge Stanley Bastian, on Thursday, September 17th, issued an injunction which prevents the post office from implementing changes to its policies which could hinder voting by mail. It will likely result in multiple state court challenges to the vote count and many delays, a victor may well not be announced on November 3rd. There's another issue in Florida dealing with people that have served jail time. Florida is a notoriously closed swing state, as noted in the Bush versus Gore summary discussed previously. Florida amended its constitution in 2018 to allow convicted felons who had served their jail time to vote in the presidential election. Certain more serious crimes are exempted. However, the new law would allow some 775,000 persons the right to vote. The issue then arose as to whether such persons would be required to pay court-ordered fines to be entitled to register to vote. The first federal judge determining this issue said that such a measure was an unconstitutional poll tax. However, this decision was reversed by a federal appeals court. An emergency application to stay or stop the order of the appeals court pending a further appeal to the United States Supreme Court was dismissed.